Guys, Angeli.
3, 2, 1. You can start.
Hi, everyone. It's Green Card with Gehi and Greg and Suryia. Today, we'll be talking about what to do if you received an NTA, notice to appear. So the notice to appear is a document that's filed with the immigration court, which initiates removal proceedings. That means the US government is, for one reason or another, wanting to remove you from the United States. So, many of our clients are in that situation, and we help them through that process. The first thing you want to do, well, let's talk about first how you may receive an NTA. How might it come against you? How could it be filed against you? So perhaps you filed an application with the immigration office, USCIS, and it was denied, or there were some issues with it for some reason. They're alleging fraud. They reviewed your criminal history, and it violated some they're alleging that it violates some provisions of the law. So they've referred your case to an immigration court for your case to be heard before an immigration judge. So we can start with what an NTA looks like. Greg, if you are ready to share with us a sample NTA.
Yes. Okay, here we go. This is a sample NTA. I have redacted them, so there's no personal information, but these are real clients and real cases that we've had. So generally the NTA will say, let me find kind of the most, okay, typical one.
Yeah, there's some complicated ones in there, but yes.
Yes, I added some very complicated ones, but this is more or less a typical NTA. There'll be 3 or 4 allegations, okay? And these are allegations followed by what they're charged with. So if you see here, this is the charges, the allegations, okay? So they'll usually start out with, you are not a citizen of the United States, you're a citizen of another country, how you got to the United States, and what how you don't have any documents or right to be here, okay? So this is a typical one. Let me see if I can zoom in. Okay. So you'll see I've redacted this all, but this is where your A number, name, and address goes. And this is like a service. So the asylum officer signed this in Houston. And this is the court that they should go to. All right. And the allegations. So this is a simple one. Like I said, there's usually 3 or 4, sometimes 5 allegations. When you will then be given a court date, as is here, okay, on why you should not be removed from the United States. Okay, at that court date, it's known as a master hearing. And what we do as attorneys is we address the allegations and removability. Now, normally, in criminal court, you go, you're charged with this, and everybody says not guilty, right? Even if you're trying to make a deal later, right? In immigration court, we admit to the allegations, usually, and I'll show you some cases where we don't. We concede removability, and then we give the reason why the respondent should stay here, okay? So if I went to court on this NTA, I would say, Your Honor, I admit allegations 1 through 5. We concede removability. We respectfully decline to designate a country of removal. And the relief we're seeking is asylum, withholding of removal, and the Convention Against Torture. And that's usually the extent of a master hearing. Now, they'll check up on addresses and stuff like that, but that's usually the extent of the master hearing. We will then be given an individual hearing date where we will have to present our case, whatever we're arguing for. In this case, it's would be asylum, okay? So admit the allegations, concede removability, and then the relief we're seeking, okay? It's fairly straightforward. Did I miss anything, Suryia?
No, I think you got it. So the most important part for the person who receives the NTA is that date at the bottom. That means they have to show up in court on that date. Otherwise, that means the person can be ordered removed by an immigration judge, and you definitely don't want that to happen. You'll definitely want to speak to an attorney to see if there are any if there's any relief available to you. So there are different kinds of relief that you can ask for from the immigration court. As Greg discussed, the main one is asylum if you're afraid to return to your country of nationality. And then there's subsets of asylum, withholding, and relief under a Convention Against Torture. So that's a very common relief that we see before the immigration court. We also see more typical kinds of relief, such as the person is eligible for a green card based on marriage to a US citizen or a green card holder, or maybe they have a US citizen child that's over 21 that can petition for them, and they're otherwise eligible to get the green card of the United States. So sometimes we see more typical requests for relief like that. There's other forms of relief, such as VAWA. That means that you were married to a US citizen or a green card holder, and that you suffered from abuse or extreme cruelty at their hands. So that's another form of relief. And finally, you can ask the court to terminate your case. You can ask them to close the case because the NTA, there's an error on the NTA. Maybe the facts were not pled right. And in those cases, that's when we don't admit to all the allegations. Maybe there is an allegation which is not true, and therefore that needs to be addressed before we ask for relief from the court. So those are the different kinds of relief you can ask from the court. And again, you want to speak to an attorney to see what kind of relief you might have before immigration court. Greg, are there any other types of relief that you can think of?
So there is 42A, 42B. We have many cases. So 42B is cancellation of removal, otherwise known as the 10-year green card. That's if you are in removal proceedings. You can only apply for it if you're already in removal proceedings. And it's based upon you've been in the United States for 10 years without being sent to immigration court. And your removal would cause extreme and unusual suffering to your US citizen or legal permanent resident family members. That's another one. 42A is legal permanent resident cancellation of removal. And that's if you already have a green card and they're trying to take it away. And there's also residency requirements for that. Let me see. So here's a NTA. We would not be admitting to all the allegations. Now you can see how there's 12 here, right? So multiple accusations of fraud. And in this case, we're doing several things. We're doing 42A, as we discussed, and we're also denying the fraud because it's not true. And 42A, which is another form of relief. Okay, he could be hardship to himself or another family member. Okay, you'll see here they have this gentleman's entire immigration history from the time he came to how he adjusted his status and what happened. And what we do see in a lot of cases is that people they come here, mistakes are made, they eventually get a green card. And when they apply to become a citizen, all this baggage gets brought up. And based upon a mistake or the government's confusion, as is in this case, they send you to immigration court. So in this case, we would be admitting to, say, allegations 1 and 2, but we're denying the rest of them because he did not commit the fraud, or we don't believe he committed the fraud that they're alleging. All right. So I do have other NTAs. One is based upon a criminal record, and one is based upon fraud. And as you saw the allegations. Here we go. Let me try. Okay, so this one was based upon fraud. Okay, this gentleman came to the United States with a visa, got married to a US citizen, got a green card, and then they alleged that when he went to remove the conditions on his green card for a 10-year green card, they're alleging that his marriage was not bona fide. It wasn't a real marriage. So we took it to court and we proved it was a real marriage. This client in particular is now a US citizen. So it was a successful case. But we had to take it to court and we had to prove that the marriage was real. And go through the 751 in court. That's the one I showed you. Okay, this is a criminal one. Okay, so this, based upon a criminal record, the respondent was put into removal proceedings. You can see it's longer as well. Okay, but generally they're just 3 or 4 allegations. But if you're in immigration court, please don't try and do it yourself. Even the first hearing. We had another client who is I believe a very strong asylum case. And her parents live in what's called a safe second country. She does not have residency in that country or any or wasn't offered residency in that country. However, she tried to do the first hearing on her own and admitted to the court that she can freely go to a other safe location that is not the United States. And it's not only was it not true, she didn't understand the facts and she admitted to this. And it's going to cause us big problems down the road. Because the US government will say, well, you already said you were a citizen of a different country. So it's very important to get an attorney. Please do not try and do court immigration proceedings by yourself. You can see by the NTAs that we showed you, there's sometimes where we admit the allegations, other times when we deny them. We will also counter the allegations. It's usually like in cancellation of removal cases, as Suryia was talking about. It will say, respondent entered the country at an unknown date and unknown time. Well, we'll counter with the date and time. If you give the wrong date and time, you could miss out on your eligibility for cancellation of removal. It's very important. Anything else?
And absolutely. And then in very rare cases, there are some times when the US government tries to deport somebody who is a US citizen. I have seen it before. It might be the case that you're a US citizen and you don't even know it. Maybe there's laws of acquiring and deriving citizenship are complicated, to say the least, and sometimes people don't even know that they're a U.S. citizen and they're eligible to apply for their citizenship certificate or a U.S. passport, but that requires a very detailed analysis by an attorney to determine if you are a citizen by operation of law. And in that case, of course, the U.S. government has no right to order you deported from your country of citizenship. So those are all different kinds of relief. Those are the major ones. There are other ones I'm sure that we can't think of right now. We've seen everything. Our principal attorney has been in practice for over 25 years now. We've been practicing for a while. Attorney Greg is in immigration court almost every day. So we know the ins and outs of what happens when you get an NTA and what happens in immigration court. So let's talk a little bit about what happens at the individual hearing. So Greg just described what might happen at a master hearing. You appear before the judge, you either admit or deny the allegations, you tell the judge what your proposed relief may be. The judge will give you time to submit evidence in support of that relief. It might be within the upcoming month or weeks, or it might be, for example, 30 days before your final hearing. Your final hearing it's also known as an individual hearing. And so we could so it could we could do a mock hearing. That would be certainly something we could do, and we could show how it's done.
You wanna test me, give me a hard time?
I don't know if I get in trouble for acting like a judge. It's an act. Just for the record, it's an act. I'm not a judge. Okay, so
Okay.
let's do it. So and these hearings are virtual, so sometimes it is like this. Obviously, your judge is not going to have a Gehi and Associates a banner in the background, but so the judge will appear. Maybe they'll have their camera on, maybe they'll have their camera off. You'll also have the government attorney there, advocating on behalf of the Department of Homeland Security to have you removed. But sometimes they will work with you if you communicate with them. Sometimes they will work with you. So it'll be in a setting like this, and the judge will call the A number. So it'll go something like this. This is fake acting attorney Judge Suryia Rahman before the New York Immigration Court. We are here today in removal proceedings in the file number, case number 123456789. Attorney for the respondent, please make your appearance.
Gregory Ippolito, Gehi and Associates, here for respondent 789.
Mr. Ippolito, is your client present today?
My client is present right here, Your Honor.
Thank you. Do you concede service of the NTA?
Yes, Your Honor, we concede proper service.
Okay, so with respect to the allegations 1 through 4, how do you plead?
We admit allegations 1 through 4 and counter in 3. Respondent entered through Nogales in October of 1972.
Thank you. Department, do you accept those counter allegations? And maybe
Yes.
the department will say yes or no. And then do you concede removability?
We concede removability, Your Honor.
and the country your client wishes to be removed to.
Respectfully, Your Honor, we decline to designate a country.
Okay, counsel, what are we doing with this case? Is there any relief that's available to your client?
Yes, Your Honor, we have two forms of relief. One is asylum, withholding, and removal, and the other is 42B cancellation of removal.
Great, so I'll go ahead and set a final hearing date. Today is July 13th, 2023. The next date in my calendar is in 2026. Will you be available on June 5th, 2026?
I'd have to check my schedule, Your Honor, but I believe I will be. Tentatively, yes.
Great, and so I'll set the individual for that date, and the call-up will be 30 days prior to the final hearing date. Anything further from the department or respondent?
No, thank you, Your Honor. Counsel, would you mind putting your email in the G chat so we can discuss this case, possible dispositions for this case?
Thank you, Mr. Ippolito. Thank you, department. This hearing is adjourned.
Thank you, counsel, and thank you, the Honorable Judge Rahman for.
Yeah, so basically that's how.
it.
That's it. That's the whole master hearing.
That's it. Sometimes if the judge wants to give you a hard time, no, excuse me, not a hard time. I actually like it when they give us more of a hard time because we get everything established before the individual hearing. They will ask, well, what are the qualifying relatives? And I, a stepmother. And they'll say, you can't use this, under what circumstances? I need a brief, right? In this case, we said the client entered the country in the 70s. Well, there's a 1-year filing deadline for asylum. That has to be addressed. And so sometimes the judges, that are known for giving us a harder time, it's actually very beneficial to the case because they'll request a brief. They'll want to know what kind of hardship. What's the basis for asylum? Is it PSG or is it political, religious? And they'll request information. And that way, by the time of the hearing in 2026, we're ready to go. I mean, it's ready to go. A lot of times, if the judge doesn't, give you a hard time, you could you show up at the hearing and nobody knows what's been going on for the past 3 years. Has anything changed? For cancellation of removal, children can age out. So if you're so very commonly the relief you're seeking is 42B cancellation of removal, they'll ask, are any of the children aging out? Sometimes they'll be able to give you a quicker date. So it's what I tell myself and the other attorneys that work here, spend at least 15 minutes, review everything, relatives, dates, times, names, and relief. You don't have to, it's only 5 minutes long. It's quite simple, but just know the case, be able to answer any question.
Right, and of course, that's 15 minutes before the hearing, but that's because we've spent a substantial amount of time
Yes.
with the client, preparing with them, making sure they have sufficient evidence, making sure they're qualified. So just to review everything before the hearing, of course. So that is a master. At the individual hearing, that is your final hearing. That is your last opportunity to ask the court for relief. You're presenting evidence. The client will be, the respondent, the client will be testifying in court. So that requires a lot of preparation. The judge, obviously, like we did in our mock hearing, they'll be setting a deadline to submit evidence. All that evidence has to be submitted in time, unless there's some extenuating circumstance. So that evidence has to be submitted in time. Usually judges require, or it definitely helps your case when there is a legal memo or a legal brief outlining why you are eligible for the relief you are asking for. So all of those things require time, require the guidance of an attorney who has experience with these things. So of course, we are here to help you with that. And so all of that work goes in before the hearing. Also before the hearing, we're going to sit down with you for several days and prepare you for the hearing. We're going to let you know what kind of questions we would ask of you when you're testifying. We would prepare you for anticipated questions from the government, the Department of Homeland Security, from their attorney. What kind of questions might they ask you? What kind of questions might the judge ask you? So we go over all of those issues and prepare you for the final hearing, so that on the day of your final hearing, there are no or very minimal surprises. So yeah, all that work goes in before the hearing, and then on the actual day of the hearing, Greg, you want to talk a little bit more about what happens on the day of the individual hearing?
Yes, so the date for the individual hearing I do, depending on the case. I don't like to give a number of like preparation times, but generally I do up to like 3. Some people need more, some people need less. But we do, we will prepare with you at length and quite a bit. At the date of the individual hearing, if it's remote, you just come to my office. If not, we go to court. Because the gravity of the situation, I like to get there very early and just go over any final details. What I do is I print out a lot of the key evidence. So if something's missing, very frequently the judge won't have an affidavit, or some file will be missing. So I like to have everything ready to go should it be needed. Okay. About 15 minutes before the hearing, the judge will usually give you a chance to speak to Homeland Security or DHS to discuss any issues. Sometimes they'll tell you, hey, this is what we want to focus on. We will stipulate to this, but we have a problem with that. We were talking about cancellation of removal earlier. Very commonly, they'll just agree to the 10-year residency requirement, as long as you submitted enough information. They'll stipulate to it. They'll just say, yeah, you don't have to go into the 10 years residency. We believe you. Let's focus on the hardship. So we'll generally kind of discuss, how we want to proceed. Then the judge will come back on, ask us if we, have any other issues to talk about before we go on the record. Once we go on the record, the judge will mark all the exhibits. So they'll go through everything that was submitted. The NTA is Exhibit 1. 99% of the time, the NTA is Exhibit 1. Exhibit 2 is the application of relief, cancellation of removal, 589, whatever it may be. Then the evidence. If it's a contested NTA, DHS will provide evidence. Like, for example, if it's due to like a criminal record or fraud, DHS would have to have provided evidence. If they don't, the case could get terminated. So they will provide evidence. After the evidence is, we go through the evidence, mark properly. Then I will usually start with the direct examination. Okay, most of the time. Sometimes DHS starts if it's a contested NTA. If there's like fraud issues, DHS will start. They've denied something. But most of the time, I will start with the direct examination, and I will just ask questions. Usually, I'll start with a biography. One of the things they like to stipulate to a lot is skip over the biography. They'll say, we believe you, you were born there. You don't have to go into it. It takes too long. So then I'll go through the relief, why I think the application should be granted. If it's cancellation of removal, we go through the family. I'll start asking, who is your wife? When did you get married? How would she suffer without your presence, right? If it's asylum, I go through past persecution. How are you a member of a group that is persecuted? Okay, is it based upon your religion? You need to establish that you are part of that religion. So you're not part of that religion, you're persecuted for other reasons. Then after I'm done, DHS will have time to do a cross-examination. And they'll do the cross-examination. Usually they'll try and pick apart any inconsistency. If in your original affidavit, you said you entered through Nogales, but now you're saying you entered through El Paso, okay? Or Juarez, where they'll usually pick apart that. They'll ask a lot about the dates. Any inconsistency, they find, they'll try and exploit. They want to make sure you're telling the truth. If you're not telling the truth, that's it's a credibility issue, and it creates big problems. After that, I'll be given a chance to do what's called a redirect, where I will follow up on some of DHS's questions. Most of the time I do this, especially if I feel like the question, if the client didn't understand the question properly, they may have given an answer that I know really wasn't thought out. I'll get them to explain it more and clarify. After this, if there's multiple witnesses, we'll go through the witnesses. Then the judge will usually ask DHS, they'll very informally, they'll say, how do you feel? And DHS, sometimes if they feel that we've made a good case, they'll say, well, we'll defer to the court. Other times they'll say, no, we disagree. They have not satisfied, the elements of an asylum claim. Relief should not be granted, or that, we should not give them relief. And if they defer, the judge will think about it. The judge could come back in 15 minutes. The judge could come back in 6 months with a decision. At the end of the hearing is usually when the judge will ask questions too. What's unique about immigration court is the judge will think about issues they have, and they'll give you they'll examine you. Okay, so you had me, you had the prosecutor, and then you have to face the judge, and the judge will ask you questions based upon their concerns, and it depends on how they feel about the case. Then sometimes you're given an oral decision right there. Other times it's scheduled for another date. Other times you get a written decision. Usually prior to the end of the hearing, we will give like a closing statement. And they'll sometimes, if the case is very adversarial, they'll sometimes we'll make several statements side by side, DHS and myself, where they'll say this, then I'll counter that, and we'll kind of fight it out at the end, based upon the narrowed issues that the court's looking at. So that happen, it's not all the time, but it does happen. So that's it. They can last anywhere from 90 minutes to 3 days. Usually it's, what would you say, Suryia, about 3 hours?
Yeah, I would say 3 to 4 hours, at least.
Average?
Yeah.
Depends on the complexity. Some of these cases, we have multiple applications. So we do 2 cases, where we, we'll have one that starts with a fraud waiver, then goes to asylum, then goes to cancellation of removal. So the complexity, it can be very quick, take forever. But we'll get it done.
Yeah, and then after all that, sometimes the judge gives a decision on the same day. And in that case, sometimes the decision is based on final security checks. So sometimes maybe the judge will say they grant an application contingent upon security checks, and that just means that the Department of Homeland Security has to do their job and check the security, make sure you haven't been arrested or done anything wrong, and then you'll have to come back again for the final decision. So that's pretty much it. What happens in a individual hearing. It's a very detailed overview. But if you're a person that's been served with the NTA and you're about to go through this process, you don't have to worry about all these things. We are happy to hear your story and do the work for you. That's what we are here for. So we have some questions from the viewers. So the first question is, after an arrest, how soon will the person be deported? Okay, so I think that question is asking for kind of like a timeline. So if you've been arrested, for example, by ICE, by crossing the border, and you were taken into custody by Customs and Border Patrol or ICE, then the process takes a while. So like we said, you have to go through a master hearing, you have to go through an individual hearing. If you remain detained, the process is a little bit faster. It might be a course of a few months. If you were released from detention, it could take anywhere between 6 months to 10 years or more. We've had clients that have had their cases from start to finish within 6 months, and others whose cases have been pending for years, and that's because the court scheduling. Of course, there was a pandemic, which kind of set everything back for a few years. Sometimes the client needs more time to gather their evidence and so we ask for a new date, but according to the court schedule, it's like years out. So there's many reasons why it can take so long. Sometimes there's a change in strategy. Maybe before, the relief you're asking for is cancellation of removal, and now one of your children have turned 21, or they've become a U.S. citizen, and they can petition for you, and you're now eligible for a green card through your child. So sometimes the strategy changes, and that also takes time. Popular response from a lawyer, it depends. Okay, so next question is, what happens once the immigration judge orders me deported? Okay, so let's say you had your master hearings, you had your individual hearing, the judge did not grant the relief that you were seeking, so the judge ordered a removal order against you. So what happens then? Does that mean like they arrest you right away and they put you in detention and they put you on a plane? No, that's not what that means. Whether or not you are arrested and detained by the immigration authorities depends on many things, many factors, which can be another day we talk about those things. But what happens is you have the right to appeal. So you have 30 days to appeal your order to the next, the higher level court, which is called the Board of Immigration Appeals, the BIA. So you have 30 days to appeal. So nothing can happen during that time unless, of course, you commit some kind of crime and that causes you to become detained. So you have time to appeal, and you also have time to ask the judge to reconsider their decision. Maybe between the time of your final hearing, you have come across evidence that was unavailable to you before, or maybe there's a change in the law. For example, some of our clients are Haitian, and USCIS has been releasing some policies on TPS for Haitians and nationals from other countries such as Cuba, Nicaragua, and different countries. So sometimes the law changes in between. So in that case, you can ask the judge to reconsider their decision. Yeah. So the next question is, how can I reopen or terminate my case? Okay, so there could be many reasons that you want to reopen your case. Greg, you want to talk about a few of the reasons that a person might want to reopen their case?
Yes, so obviously if you had a removal order is the biggest reason you want to reopen your case. We have some clients that they don't have anyone to petition for them. They've lost their either asylum or cancellation or removal case, and then they have someone that can petition for them. So we would reopen it so they can adjust their status afterwards. I'd say one of the most difficult issues that we had are people who were granted relief, but that relief isn't legal permanent residency. So for example, if you're granted withholding of removal, and then you get married to, years later, you get married to a US citizen and you want a green card, we would try and reopen the case then. And so you can adjust your status to a legal permanent resident. Those are fairly difficult because everybody thinks you won, you got relief. Why are we gonna mess this up? They think you won, what more do you want? So those are kind of more difficult cases to reopen, but we do get it done. Mostly it's because there's another avenue for relief that wasn't available at the time of the hearing. We would seek to reopen, especially marriage, or like I said, or your child turns 21 and they can petition for you. We would seek to reopen, get rid of the removal order and get you, your status adjusted. It could all be based on country conditions. If you're from if you're ordered removed, but all of a sudden there's a war in your country, or things have gotten very bad, you can reopen your case and due to change country conditions.
Right. Yeah, there are numerous bases on which you can reopen your case. But yeah, the most popular one is that you have a petitioner now. You have a US citizen spouse or a child that can petition for you. That's the most common thing that we see. If somebody's removal order is not reopened or vacated, can they still get their green card? It is possible. It requires waivers, and it requires, a lot of procedural maneuvering. So that's something you definitely want to discuss with an immigration attorney before you move forward with that. Okay, next question. What are the most common reasons for deportation? So, the most common reasons are you crossed the border and you were detained by ICE or CBP. or you are already within the United States and you've committed a crime. And that will, after you've been processed by the local authorities for your arrest, they will refer your case to immigration for them to process an NTA. So those are the two main reasons. Or for example, if you filed an asylum app, you came here on a visa, you filed an asylum application with the immigration office, and the immigration office did not accept, they refer it to the immigration court. So that's another common reason that you might end up in removal proceedings. Okay, next question. After removal, is there any possibility for me to re-enter the United States? Yes, there is. So if you have been order removed and physically removed from the United States, you might be subject to a bar, which would prevent you from applying for any kind of immigration benefit. But there are waivers which you can apply for if you qualify for them. So if you are in those circumstances, we would be happy to talk to you about whether you qualify for a waiver. Okay, what happens after the presence of an undocumented immigrant is revealed to the immigration authorities? So that depends. It depends. So those policies are determined by the political heads of government. So a lot of it depends on who is in office and their priorities. And change in administration, their ICE releases what's called their removal priorities. So based on that, if you are undocumented, you have never been arrested, you haven't done anything wrong, they might not, not do anything. They might not issue an NTA. In other administrations, just the fact of being undocumented might end up with you being issued an NTA. So it really depends. The administration we have now is focusing their priorities on different things. So generally in this administration, if you're undocumented, you haven't committed any violent crimes, you should be okay and not receive any kind of NTA. But that's generally speaking, of course. Okay, so we'll just take two more questions and then we'll wrap it up. Okay, so ICE has put me in deportation proceedings. Is it too late for me to marry a US citizen? Well, my answer is marriage all depends on love. So if you are emotionally ready for marriage, that is the right time to marry somebody, first and foremost. So let's say you've been dating a US citizen or green card holder, and you've decided now is the right time for marriage. You happen to be in deportation proceedings. So is it too late? No, it's not too late. We've had clients who are in detention get married while they are detained. So if the time is right, it's never too late. Okay, final question. What are the legal rights after a grant of cancellation of removal? So Greg, you're welcome to answer that one.
The legal rights after granting cancellation of removal. So after you receive a grant of cancellation of removal, you have to wait for the visa to become ready. I don't recall the number off the top of my head, but the government just allows, it's like 30,000 of these grants a year. So I think the wait time is a year. And after a year, you will receive a green card. You'll have to do background check, the security checks, etc. But you will be a legal permanent resident, and you can apply for citizenship in 5 years after your grant. But you have to wait for your green card, but you'll be a legal permanent resident. That's your legal right.
Yeah, and I apologize, go ahead.
Oh, no, I was just.
And a lot of times, even after the judge grants your case, there is some follow-up work that needs to be done in order to make sure you receive all the proper documentation related to the relief that you were granted by the judge. So these are very good questions from our viewers. We hope this was informational to everyone. Of course, this is general information. This is not nothing today or anytime in this program is intended to be relied on for any person's individual specific case. We encourage you to speak to an attorney, someone with experience, someone with guidance, such as us. We have 3 offices. We have an office in Jackson Heights, New York. We have an office in Jamaica, New York, and another office in Ozone Park, New York, which is where Greg has his office. And
Yes.
we
Come
would
to Ozone, visit me. I'm here all the time, 6 days a
Yes,
week.
exactly. Yes.
I'm lonely. You can come visit me. Okay.
We are there for you. So please come see us. We'd love to talk to you about your case, about what you're entitled to, how to maneuver the immigration system, what you need to do. We'd be happy to discuss all of that with you. So thank you for joining us. Thank you, Greg, for your time, and we will see you all next week. Thank you, everyone.
Thank you.